Let's get into that side of this, the actual legal side of these
Sure.
laws. So we now have 3 new ones. They've all been challenged to varying degrees of success at this point. You still have the California law in active litigation. That's actually, we're probably going to get some ruling there soon at the district court level. You have the Supreme Court remanding the Maryland assault weapons ban case. We're probably going to presumably get a ruling in that sometime in the relatively near future. Where do you see things in terms of fighting these AR-15 bans right now? What's the legal landscape look like?
Well, the legal landscape looks swell to the extent that lower courts follow what Supreme Court precedent says. But that is, there's no guarantee on that one. Sometimes that happens and sometimes it doesn't. And the gun ban lobbies, mainly Bloomberg's Everytown and the Giffords organization, which also has lots of support from the ultra rich. They have an enormous amount of money, and they hire lots of really good lawyers who come up with, I think, ridiculous arguments to try to evade what the Supreme Court said. But they're well presented in the briefs, and some judges who are inclined to go in that direction follow that. And of course, and you layer on top of that the whole disinformation campaign waged by the gun ban lobbies about that the AR rifle bullet, either the 223 is what they would say, or obviously it's also for 5.56 millimeter, is some uniquely destructive thing that liquefies organs and stuff like that. And of course, that's a complete lie. But you get that out there in the media, then a judge can cite an article in a magazine that said that, even though it's completely false. And it is, rifles in general are much more powerful than handguns. But within the class of centerfire rifles, most AR type rifles are at the lower end of power because their bullets so small.
Yeah, muzzle energy is lower for most 223 5.56 rifles than it is for 30-06 or
just about everything else.
Basically,
other than a 22.
Other than 22, right? So, but we're in this post-Bruin era now. The Supreme Court has set out a new standard for how lower courts are meant to decide Second Amendment cases. This is one of the highest profile sections of that particular area of law. We have seen rulings in Delaware, for instance. They had the district court just recently, ruled against a request for a preliminary injunction against their assault weapons ban, and he used a logic that I think is becoming more popular for judges who wish to uphold certain kinds of hardware bans under the Bruin standard. Can you just go through and explain for the audience what the logic was in this case and your thoughts on it?
Sure. And there's a tendency among pro-Constitution lawyers on Second Amendment issues and on other things to think that being right under constitutional law is all you need to do to win a case. But that's not often the situation. So you can come into court and say, look, the Heller case said you can't ban arms that are in common use, arms that are typically used by law-abiding citizens for lawful purposes such as self-defense. And then all you got to do is show that the banned guns are common, which these days is quite easy to do.
Right.
And therefore that's the end of the case, and we should win and give us a preliminary injunction right now. So in Delaware, that's basically what they did. And at the preliminary injunction stage, introduced no evidence, no declarations, things like that by experts. Because why should we have to? Because what I just said is both necessary and sufficient for us to win. Well, the other side comes in, and they do have these declarations, and they, from purported experts, including these outrageous falsehoods about the AR supposedly being used in most mass shootings, and about how super powerful the 223 round is, which is ridiculous. Mm-hmm. But from the point of view of a judge who's no expert on guns necessarily, if you like being a generalist in law and all kinds of different law, being a federal judge is great because you see all kinds of cases. And so this judge, seeing on the one hand no evidence from the plaintiffs, and seeing from the state government these declarations talking about liquefying organs and things like that, most judges are got to be judges because they're very much color within the lines kind of people their whole career. John Roberts is the platonic ideal of that. And this is not an ideological thing, but I'm saying they're, by character and practice, they tend to be prudent and careful people, regardless of their ideological views on law.
Sure.
So, imagine a person like that, and you got one person coming in saying, oh, here's our verbal formulation, this is why we win. And the other person says, well, on the other hand, you really want to go, these super powerful guns that liquefy organs. You can understand why the judge at that level says, well, not having any evidence going the other way, at this stage, I'm not going to give you the extraordinary remedy of a preliminary injunction, which is basically saying you're very likely to, after we have the trial and all the evidence comes in and the cross-examination and all that, then, and I've had a chance to do some fact finding, maybe I'll see things differently. But at this point, with no evidence on one side and horrifying supposed evidence on the other, I'm not going to give you guys the preliminary remedy of saying this law can't go into effect.
Interesting.
And the rationale the judge in Delaware used is that the Bruin case does, in many situations, instruct, if the gun controls you can uphold are the ones that you can analogize to the mainstream historic tradition of American gun control, which is especially things that come closer to the founding.
Right.
And you don't have to, a law doesn't have to be a twin of something historical. It can be analogized. And
right. Especially if there's some sort of unique modern problem derived from a modern firearms technology. Right?
Exactly.
That's what a lot of you've seen this over and over again to this, like
right.
Oregon's, the federal judge in Oregon's magazine ban case used very similar logic to the Delaware Sullivan's ban case judge.
Exactly. And you can be more, and Bruin says you can be more nuanced when you're dealing with new technologies.